It has been nearly 1 year since the alleged assassination attempt of President Trump at his own golf course in Florida. That was the second incident of its kind in just a matter of months during his presidential campaign. Well, today, jury selection is set to begin in the federal trial for the man accused of plotting that attempt.
Yeah, that's for Ryan Routh, and he's chosen to defend himself against 5 criminal charges, including attempted assassination of a major presidential candidate. If convicted, he could face life in prison. He's pleaded not guilty.
NBC News legal analyst Danny Cevallos is here with more on what to expect today. Danny, good morning. So at a pretrial hearing, Routh first addressed the court by saying, obviously, I'm new to all this. I mean, these are serious charges. In a case of this magnitude, how rare is it to see a defendant defend himself?
Pro se defendants are at once the bane and the glory of the legal system. They are the bane for the actual litigants, for the prosecutor and the judge. But for observers like me, they are fascinating. I have a guilty pleasure. This is my pro se defendant playlist on YouTube on my phone. That's how much I like watching pro se defendants, because they're fascinating. They are at once a celebration of the Constitution, but they're an utter disaster. These charges are actually, some of them might actually be defensible, because Routh never fired a shot. There's only some circumstantial evidence that this might have been an assassination attempt. But he will almost certainly lose, because pro se defendants lose. As he said, he's new at all this, but the rules require, theoretically, that the judge consider that he knows all the same rules as an attorney when you represent yourself pro se. The reality is they don't do that. They give him something of a break, but chaos will result.
There's already been some interesting happenings. I mean, federal prosecutors have already limited what he can say at trial because of this pre-trial motion with these unconventional requests that he filed. For example, it included a suggestion that the case could be decided in a round of golf with the president.
That was the most benign thing in the motion, yes.
Right, so
but go
tell
ahead.
us more about what was in there and how that kind of sets the tone for what we're going to see.
Oh, there was really references, I think, to a knockdown, drag-out brawl suggested by the defendant with the president. I believe there was a reference to strippers, golf, all kinds of stuff in that pro se. But by the way, as someone who has seen a lot of pro se defendants, those kinds of filings are not that unusual. They just file gobbledygook. It's just chaos when they're involved. And they write them from prison. They send them in. The court has to file it. Here's the thing. The prosecution wisely is making motions and getting orders so that Routh can't raise all kinds of nonsense during the trial. But good luck enforcing it. What do they care? The defendant doesn't care. He'll cause absolute mayhem. And what's the judge going to do? She still has to try the case. So this happens all the time. We've seen them in the rare instance when a pro se actually goes to trial, which is exceedingly rare. When they do go to trial, there's very little a judge can do to stop them from disrupting it with their nonsense.
Let's talk about the judge, because it's a Trump-appointed judge, Aileen Cannon, who, if people remember, she was the judge in a case where President Trump was actually the defendant. Back when Routh had public defenders, they tried to get her removed from the case. She refused. What is this going to be like for her trying to manage the courtroom here? How tight of a leash do you expect her to keep Routh on?
Yeah, I thought this was a good motion back when Routh actually had counsel representing him. And by the way, he may still have standby counsel. An interesting rule is this, that a defendant has a qualified constitutional right to represent himself. It really isn't an absolute right. The judge can say either you're not competent, or the judge, if the testing shows that, or the judge can say you're just, too chaotic. I'm going to need someone to represent you, at least on standby. So standby counsel can be appointed even against the will of the defendant. So they'll be there and be available. Whether the defendant uses them is up to him. So here you have Aileen Cannon. I'm a little surprised she didn't recuse herself. It could be a bit of exposure on appeal for when he almost certainly gets convicted. But all that really means is that the judge is choosing to handle this case herself, which, frankly, most judges want nothing to do with a pro se defendant. Surprised she didn't recuse for that reason.
Danny, very quickly, what does this mean for how the prosecution constructs a case, knowing that this is on the other side?
Oh, this is a real challenge for them. Yes, they're almost certainly going to win, but every day is going to bring the unexpected. And by the way, don't be surprised if Routh reconsiders it. A lot of these defendants will go right up to the line. Maybe they'll switch between attorney and self-representation just for delay. But any defendant a lot of them are playing games, any defendant who has any self-preservation in mind, ultimately, when it gets to trial, the ruse disappears and they say, I think I actually need that attorney now.
We thank you for watching, and remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.